Harry here to talk about the birthright citizenship case, the very one that the Supreme Court decided, but in its aftermath. So recall, Supreme Court gets an opinion that originates in a district court in Washington State that holds the birthright citizenship in the Constitution means exactly what it says, namely, if you're born here, you are a citizen. The Trump administration published this Orwellian executive order trying to say it doesn't mean that, and in particular, that if you are the child of people who aren't here legally, you cannot be a citizen. That would hugely overturn the whole regime. Obviously, the administration hopes it would serve as a disincentive. People wouldn't want to come here to pursue the American dream if their children weren't going to be part of it. All right, so just very briefly, because it's just not worth thinking about too much. It's so far-fetched, although the Ninth Circuit did. The administration's argument is basically that the language of the 14th Amendment says subject to the jurisdiction thereof, and argues the administration, if you're born here and your parents are illegals, you are not subject to the jurisdiction thereof. Why not? Well, no reason. It doesn't make any sense. If it were right, children of people here illegally couldn't get driver's license, couldn't enter into contracts, couldn't get married. If they injured someone, couldn't be sued. The would be somewhat like, more than somewhat like, diplomats who are not subject to the jurisdiction of the United States. So it really is A, unworkable, B, completely mangles the original meaning, has no support in anything we know about the legislative history and the like. Okay, but that's their position. The district court rejected it, enters a nationwide injunction. The Ninth Circuit, which is right above the district court, doesn't disturb that injunction, goes to the Supreme Court just on the nationwide injunction case, and they strike that nationwide stay down. But what they say is courts must give relief, complete relief to the parties in front of them. That's why some people aren't thinking about class actions now. To give relief to an entire class might be akin to a nationwide injunction. Here, the plaintiffs are largely states. There are a few individual pregnant women whose children are about to be born, and that gets into a little brouhaha about standing. But basically, we have all these states, and the state's argument that the Ninth Circuit accepted is, in order to give us, just us, complete relief, us 20 or so states, it's got to be a nationwide injunction, because it couldn't work any other way. You couldn't, the states, individual states, are not able to make determinations of nationwide citizenship. So if children are born in one state and come to another state, like the states who are plaintiffs, there'd be no way to verify, at least under the current system. And in order to give complete relief, to know that all the kids of illegals within any state borders are actually fine and are citizens of the U.S., you need to have their citizenship be established by being born within the United States. There's no way to break it down to Montana versus, New York versus South Carolina. So in order to provide complete relief, and that's something the Supreme Court said you can and must do, the Ninth Circuit says we are going to make this nationwide. You could call it nationwide, or you could just say this is what it requires to give complete relief to the parties. Okay, so very long, methodical, and sort of every different kind of interpretive aid in the book the Ninth Circuit uses to come at what probably they regard, and most scholars do, as a very straightforward question. You just look at the plain meaning of the text, but they know very well that this very case from what the Supreme Court said, is now going to go up on the merits. They've granted a injunction now based on the merits. So this is the opinion that may well go to the Supreme Court on the decision about the actual merits and the interpretation of the administration for birthright citizenship. Okay, and maybe with that in mind, there is a concurring in part and dissenting in part opinion by a Trump appointee, Circuit Judge Bumate. And the headline here is to say the judge does not dispute the proper interpretation of the 14th Amendment. In fact, the judge doesn't even cover the proper interpretation of the 14th Amendment, but rather says that there is no standing for the states at this point because the claims they are raising are speculative and haven't really developed to the point you would need to have children born other places come into the jurisdiction of the states. That hasn't happened yet. So for that reason, there isn't any standing. And there's a whole lot of stuff about separation of powers and the need to respect judicial limits. It's sort of music to the ears, at least of a certain stripe of Republican as it used to be. So bottom line is that there's no disagreement. And from the start, when this came up, it seemed like a interpretation that could never fly, maybe even one in an overall sort of Machiavellian strategy, a sort of sacrificial lamb. We'll give them all this stuff that will outrage them, and this one might even be a loss, and that's okay if we can push the envelope farther. Some have suggested because it's so far fetched, but in any event, the state of play now is the Ninth Circuit has re-entered the injunction from the judge in Washington. And so it's now really exactly where it was before, except the Supreme Court had said you can't give nationwide injunctions. So they're saying this is not a nationwide injunction. Technically, it's one to give full relief to the parties. How's the court going to look at that? Will they think it's a little bit, of a workaround, their opinion? It really isn't. It's straightforward, unless they are somehow skeptical about the claim that you need nationwide jurisdiction to and a nationwide injunction to really give full relief to states. I think that argument is pretty straightforward. The argument that they may be attracted to if they're in a reversing frame of mind is the one by the Trump judge who's saying the states don't have standing, and then the individual moms, one has already given birth, the other may soon, and that would change their standing because the standing would be of their newborns, except the way the act works is once you're born, you're strange way to put it, but you're grandfathered, as it were. And so what you really need is someone who hasn't been born yet, but is about to be. So that's the little wrinkles of standing that could figure in important ways in the Supreme Court review if it decides to take the case again and actually answer the big constitutional question. But for now, there's really no dissent anywhere in the courts on that question. And there's just the issue that this presents of, is there standing for the states? And, will it possibly go off on that direction that they shouldn't have taken it up in the first place because the injuries are premature? That's the focus if it goes up to the Supreme Court again. And of course, they'll have other cases that do. They guaranteed that by their very decision, because you're going to have, if you don't grant nationwide injunctions, you shop around to different places. So now the Ninth Circuit has said, this injunction controls the whole nation. Supreme Court may be looking to weigh in on that, possibly even quickly, as the administration exhorts them to do. So that'll be the next step. The bottom line, 14th Amendment position of the administration is even more just barely respectable and not expected to prevail, but still messy stuff on scope of relief, who gets relief, and the like. And the Supreme Court might be of a mind to weigh in response to the Ninth Circuit opinion, basically saying we're going to keep it nationwide because that's what we have to do to give complete relief to the states. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.